Okay, now we're moving to screencast 5 and 6, or video 5 and 6, and we're going to look at the respondent brief. Again, remember, by this point you guys should have picked which side of the question you're on, and the first part we're going to deal with is the notice side. Was Abercrombie legally informed of Eloff's religious belief? And then we'll deal with the undue burden part in a separate screencast after that. So again, here remember, clearly the respondent is the EEOC who's representing Eloff, and they're going to make an argument that Abercrombie and Finch was notified. And again, the key thing here is, remember, the testimony really does show that Eloff did not bring up her Muslim faith during the interview, that she did not bring up that she wore a head covering because of her Muslim faith, and she certainly did not inform Abercrombie directly that they needed to, or that she was requesting a religious accommodation. What you're going to see a lot of times in this is that Eloff and the EEOC are going to be arguing for a more flexible and a more, what they would call maybe practical approach to that information. And so the key thing you're looking for here are precedent and reasoning that supports a more flexible standard. So you can see in a case called Dixon, they held that holding that the employer's awareness of the religious belief was sufficient to satisfy the standard, even though the plaintiff did not affirmatively inform the employer of their religious belief. You're going to see several pieces of reasoning in cases that follow that same line, but this supports the more flexible approach that the EEOC representing Eloff is trying to argue. So in the second paragraph, you can see clearly that phrase, a more flexible, common sense approach. That's what you're going to be focusing on in this side. And they're ultimately arguing, just to go back here for a second, that it's okay that that we require employers to accommodate a person's religious belief, even if they learn that religious belief from a source other than the person who is the employee or the person who is interviewing for the job. Here you see an argument against a very hyper-technical or rigid approach to this notice argument. And again, that's the whole thing. Those of you doing this two-sided of the case, when you're arguing for Abercrombie, you're going to argue for a very strict interpretation of that. When you're arguing for the EEOC representing Eloff, you're going to argue for a less technical, more flexible approach to that. And you can see several cases that support that. You can see that they address that employers are not required to ask applicants about their religious belief, but they are allowed to make certain conclusions about that. Here's where you got a very important piece. Gannett, the Abercrombie official who interviewed Eloff, here's where she testified that she was aware Eloff was a Muslim and that she wore her headscarf for religious reasons. That's pretty much what the EEOC and Eloff are focusing on here, that even though Eloff didn't make the notification, which Abercrombie indicates she should have to do, they're arguing that Gannett already knew it. Now, again, don't think that that means you automatically side with Gannett. If you look back at the appellant brief, Abercrombie makes some really strong arguments as to why saying this is acceptable notice down the road could cause some problems. And so as you're developing your case on both sides, you're combining trying to use past court precedent, those past court decisions that support your position, but you're also doing some logical reasoning. If the Supreme Court rules in a particular way, here are the bad things that might happen. The appellant brief makes certain arguments on one side, the respondent brief makes it on the other. Here you see that they are arguing against what Abercrombie said in the appellant brief, that this would require employers to try to read the minds of the people who are applying for jobs. The phrase here is clairvoyant experts that you see that they use a couple of times. Here, the EEOC argues against that. And ultimately, as you move through the rest of this, what you would see is that the key thing here is if you're arguing this side of the notice case, you're arguing for a more flexible, less technical approach. If you're arguing from the side of Abercrombie, as we talked about before, you're looking for a more strict approach. And the key thing is both of those sides have good arguments. In a sense, what you want to try to convince the court is that bad things will happen if you take one side versus the other. And of course, you'll be arguing both sides. So I'm going to go ahead and stop there, and then we'll do the second part of this brief in just a second.